Today's article covers employment rights, specifically the ones most people don't know they have. The common mental model is that employment rights are something you build up over time, starting from nothing during probation. The reality is more nuanced and more protective than most employees realize. The probation myth is pervasive. Many employees believe that during a probation period, the employer has effectively unlimited power and the employee has none. This is incorrect. The 2-year rule, the threshold for unfair dismissal claims, creates a genuine gap in protection for a specific type of claim. But it is not a statement about when your employment rights begin. The Equality Act, the Employment Rights Act, and whistleblower legislation all provide protections that apply from day one, week one, or before employment even starts. The first day one right most people don't know about: the right to a written statement of employment particulars. Since April 2020, every employer must provide this on or before the first day of work, not after a probation period ends, not when the employer gets around to it. On or before the first day, the statement must include the job title, pay rate, hours, holiday entitlement, notice periods, and place of work. If you haven't received one, request it. Failure to provide it is a breach, and an employment tribunal can award up to 4 weeks' pay as compensation. National minimum wage applies to workers from day one, not just employees, but workers, which includes many people on freelance arrangements and 0-hours contracts. There is no qualifying period. If you are being paid below the applicable rate, you can recover underpayments through HMRC enforcement or an employment tribunal claim. Itemized payslips are a day one right for both employees and workers. Since 2019, this right was extended beyond employees to include the broader category of workers. For those whose pay varies, hourly rated or commission-based workers, the payslip must show how the variable pay was calculated. If it does not, and this results in undisclosed deductions, you can bring a claim to recover those amounts. The Equality Act 2010 provides day one protection from discrimination on 9 protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex, and sexual orientation. This applies from the recruitment stage, before employment even begins, through the course of employment, and even after it ends. There is no qualifying period. Direct discrimination, indirect discrimination, harassment, and victimization are all prohibited from day one. Whistleblower protections are also day one rights. If you make a protected disclosure, reporting a criminal offense, a health and safety risk, a miscarriage of justice, environmental damage, or a deliberate cover-up, you cannot be lawfully dismissed or subjected to detriment as a result. A dismissal for making a protected disclosure is automatically unfair. No service requirement applies. This protection is real, and it is commonly misunderstood. Some rights do build up over time. Statutory sick pay becomes available after 4 consecutive days of sickness, provided you earn above the lower earnings limit. Flexible working requests can now be made from day one under 2024 changes. Unfair dismissal protection and statutory redundancy pay both require 2 years of continuous employment. Knowing the difference between day one rights and accruing rights is important for understanding where you stand at any point in your employment. A widely misunderstood area: pay reduction. Your employer cannot reduce your pay or change your contractual terms without your explicit agreement. This applies at any point, during probation, after 2 years, at any time. If your employer attempts to impose a pay cut without your consent, this may constitute an unlawful deduction from wages under the Employment Rights Act 1996. The important thing to know: if you continue working without objecting, courts may treat this as implied acceptance. Write to your employer clearly stating that you do not agree to the change, but are continuing to work under protest. This preserves your ability to bring a claim. If an employer imposes a fundamental change to your contract, not just a pay cut, but a change to core terms like duties, location, or hours, and you resign as a result, you may have a claim for constructive dismissal. This requires 2 years of service and can be a high-risk strategy without legal advice. Constructive dismissal is not a claim you make while still employed. It requires resignation. Get advice before taking this route. The right to disconnect is an area where the UK offers partial, imperfect protection. France, Ireland, and Belgium have statutory rights to disconnect outside working hours. The UK does not, yet. But several frameworks provide partial protection. The working time regulations cap working hours at 48 per week on average, with an opt-out available. The employer's health and safety duty includes mental health, and the implied term of mutual trust and confidence in every employment contract may be breached by systematic demands for unlimited availability. These are not clean rights, but they are not nothing. Holiday pay is an area where many employees are underpaid without knowing it. The 5.6 weeks of statutory annual leave accrues from day one, but the pay rate for those holidays must reflect average earnings, not just base salary. If you regularly work overtime or receive commission, your holiday pay must be based on an average of the previous 52 weeks' pay. This rule was established through a series of employment tribunal and Supreme Court cases and is still systematically ignored by many employers. On references, there is no legal right to a positive reference, but there is protection against a false or misleading one. An employer who provides a reference owes a duty of care to both you and the prospective employer. A negligently inaccurate reference can give rise to a claim. A deliberately misleading reference may constitute defamation. You have the right to request a copy of a reference under a subject access request under UK GDPR. The employer may resist, but the right exists. Workplace monitoring. Employers can monitor company devices and systems, but they must inform employees that monitoring takes place. Under UK GDPR, monitoring must be proportionate, necessary, and transparent. Blanket covert surveillance is unlikely to be lawful, and employers cannot access personal email accounts or personal devices without consent, even if that device has a work application installed on it. A monitoring policy must be documented and communicated clearly. Redundancy contains several less-known protections. Selection for redundancy cannot be based on protected characteristics. If a selection pool contains disproportionate numbers of a particular protected group, this may indicate indirect discrimination. The duty to consult requires employers to genuinely explore alternatives before making someone redundant. You are entitled to reasonable paid time off to look for another job during the notice period. And redundancy during pregnancy is automatically unfair. The flexible working right was strengthened in 2024. Employees can now make a flexible working request from day one. The previous qualifying period of 26 weeks was removed. Employers still have 8 statutory grounds to refuse, but they must consider the request and respond within 2 months. Employees can make up to 2 requests per year. This is a meaningful change from the pre-2024 position where you had to wait 6 months before even asking. The employment tribunal time limit is one of the most critical pieces of information in this article. For most claims, unfair dismissal, unlawful deduction from wages, discrimination, the time limit is 3 months less 1 day from the date of the act complained of. This is a strict limit. Courts rarely extend it, and a grievance procedure does not pause the clock. The only thing that pauses it is ACAS early conciliation, and you must initiate that before the deadline. Know the date of the alleged breach. Count 3 months less 1 day. That is your hard deadline. If your employment rights are breached, the process is document everything first while your access to emails, payslips, and communications is unrestricted. Raise a formal written grievance. This is both a legal step and a paper trail. Contact ACAS for early conciliation. This is mandatory before a tribunal claim can be filed, and it pauses the time limit clock. And if the matter is not resolved, file an employment tribunal claim within the deadline. At any stage in this process, getting advice from Citizens Advice or an employment solicitor significantly improves your position. A summary of what employers can and cannot do at any point in the employment relationship. They can set dress codes, monitor company devices after informing you, require specific hours if contractually agreed, and implement non-compete clauses within reasonable limits. They cannot reduce your pay without your agreement, dismiss you for making a protected disclosure, discriminate on protected characteristics, or impose fundamental contract changes without your consent. The cannot do list applies regardless of how long you have worked there. The full article at realsyllabus.com covers all 5 day 1 rights in detail, the rights that build up over time, what employers cannot do at any point, and the complete process for bringing a claim to the employment tribunal. If you are in a situation where you believe your rights have been breached, the article ends with a step-by-step process and the exact time limits you need to know. Don't miss the 3-month minus 1 day deadline. That is the one that most people discover too late.